Good afternoon, good morning, good evening, everyone. My name is John McKenzie. On behalf of Baker & McKenzie, I'd like to welcome you to the third session of our virtual mid-year Global Trade Conference. I hope that many of you were able to participate in the sessions that we had earlier today, focusing on export controls and then subsequently customs and import issues. At that point, focused on the US, Canada, UK, and the European Union. Now we'd like to shift our focus, and as you can see on the slide, our focus for this session, this is the third session in our program, will be on China export and trade developments, especially a number of very current trade developments and regulatory developments that have been issued just in the last few days. So I hope that this will be a very interesting program and a counterpoint to the focus on previously on North American and Western European trade issues. We want to make this program as useful and beneficial to all of you as we possibly can. I hope that you all received from an email from Baker & McKenzie with all of the program materials. If you did not, the link to the program materials is available in the chat if you want to either download those materials or follow along as we go through the presentation in the course of the next few minutes. Similarly, to make this as useful as possible, we are recording the sessions, and we'll be happy to make those recordings available for all of you as well following the conclusion of the conference. And thirdly, we very much invite your questions, your comments, your participation in the program. There is a Q&A button at the bottom of your screen. Please feel free to lob in your questions. Time permitting, we will try and answer those questions in real time during the course of the program, or at the conclusion of the program, I should say. If we are unable to provide the answers to all the questions by the end of the session, we will revert to you by email with specific answers to your questions. The program has been approved for continuing education, CLE, CPE, and so forth. And at the conclusion of the conference, I will read off the magic code for that continuing legal education. You should have received from them in the materials that we sent out yesterday a form for applying for that credit. Please do return it to us within 72 hours so that we can make sure that you get the credit that you need in the continuing education program. So that by way of housekeeping. I guess one other point, that some of us will be giving the presentations remotely from home or elsewhere. So please excuse us if there's any background traffic noise, a barking dog, or a ringing doorbell. We'll try to minimize that, but just the fact that we're working remotely may occasion that sort of thing. Now, with all of that, it is my great pleasure to introduce my colleagues and friends who will be giving us the presentations in the course of the next few moments, sharing their expertise with us on these important China trade issues. So introducing them, Frank Pan, a partner in our Shanghai office, and Tina Lee, an attorney in our Shanghai office, and Ivy Tan, an attorney in our office in Singapore. Frank, Tina, and Ivy are really our experts in these China trade issues. And we are so grateful that they've gotten up at a very early hour, I should say, in China and Singapore to share their expertise with us. So with that by way of introduction, please let me turn the program over to Frank to start our discussion of these China trade issues. Frank?
Thank you very much, John, for this generous introduction, and very pleased to be here to present on this China topic. So today, we will first talk about the China's anti-foreign sanctions measures against the foreign sanctions toward China. So let's move on to the next slide. The next one, please. Yeah, so every time we do this type of discussion, we will first do a quick review of China's retaliatory toolkit. So the good news is this list of the countermeasures does not get longer compared with this time last year, but there are still some very important developments that are worth updating. So by a chronological order, you can see here, we put together a list of the currently effective Chinese retaliatory countermeasures. So first one is the so-called unreliable entity list, which has been in place for almost 2 years. And this list aims to sanction the companies, especially the foreign companies that has suspended the so-called normal transactions with Chinese parties without the justifiable business reasons. And there has been no development on this list. There has been no designations made under this regime, and even no rumor about which company will be listed, as we have heard a few years ago. So this regime has been largely kept dormant so far. And secondly, China now has an export control law, which has been in effect for almost 2 years already. And under that ECL, the export control law, there is a blacklisting regime. And that ECL's blacklist is quite similar to the entity list under the EAR. It targets not just the companies that has violated the end user commitment under the export control law, but also those has been acting contrary to China's national security and interest. So I think what's important about this regime is, although there has been no designation under that list, but it is worth noting that there has been increasingly concerns about a company's export sales from China being considered as violating China's national security, even though the items being exported are not on any of Chinese control lists. That's because under the Chinese ECL, in addition to the list-based control regime, which only controls the items described on China's export control lists, it also has a end user-based controls, which basically controls any item which are destined for end use or end users that are prohibited under the ECL. So one of the most important prohibited end use in this regard, as my colleague Ivy will speak to in more detail in her part, is the end use that will be considered as threatening China's national security. So if your export sales is falling under that category of end use, then the potential consequence may be, in addition to a penalty imposed by the Chinese authority, but also a risk of being blacklisted under this blacklisting regime of the ECL. And thirdly, on this list, we know there's a blocking statute rolled out by the Chinese Ministry of Commerce, or MOFCOM, in the year 2021. And that blocking statute is to block the enforcement of foreign sanctions in China, quite similar to the equivalent regimes in EU or Canada. But unlike those equivalent foreign regimes, this blocking statute of China relies almost entirely on the prohibitive orders issued by MOFCOM to designate the foreign laws that should be blocked. But so far, there has been no prohibitive orders being issued by MOFCOM so far. So this regime, again, has been largely kept dormant so far. And then the last one on the list is the Anti-Foreign Sanctions Law. This law contains 2 pillars, one of which is the so-called retaliatory sanctions mechanism. And under that sanctions regime, there have been a number of foreign individuals and the companies being sanctioned. So we will spend a bit more time talking about this particular legislation. So if we can move on to the next slide. So as we mentioned, there are 2 pillars under the Anti-Foreign Sanctions Law, or AFSL. The first, these 2 pillars are the retaliatory sanctions mechanism and also a blocking mechanism. So we first look at the retaliatory sanctions mechanism. So under this sanctions regime, despite the vague language of the law itself, based on our observations and interpretations of the law, there are two categories of targets that could be sanctioned under this sanctions regime. So the first category of targets are the companies or individuals directly involved in the formulation of sanctions measures against China. So the foreign entities currently being sanctioned under this category are mostly the foreign politicians and their affiliated think tanks. So in other words, if you are just an ordinary multinational company and you have complied with the, for example, US sanctions against China, you are still very unlikely to be targeted as a sanctioned party under this regime, based on observations we have so far. And then the second category are the companies that are considered as threatening China's national security. So the threshold for triggering the sanctions under this category, based on our observation, is still very high. The only entities, foreign entities that are being sanctioned for this reason are those who have sold arms to Taiwan. So this may be an example showing how high the threshold could be. So if you're just complying with the foreign sanctions against China, the likelihood that this sanction will be triggered could also be relatively low. And then let's move on to the second pillar of the anti-foreign sanctions law, which is the blocking mechanism. This blocking mechanism is quite similar to the blocking statute as we mentioned earlier. So it basically prohibits any company from complying with foreign sanctions measures that are considered as discriminatory to China. So technically speaking, any company that chooses to comply with the foreign sanctions against China, for example, if you refuse to sell the products to a Chinese entity on the entity list, then technically speaking, this refusal to sell violates the blocking provision of the anti-foreign sanctions law. However, the law itself does not specify any penalty for this violation. So there is unlikely to be any civil or criminal penalty resulting from the violation of this blocking provision of the anti-foreign sanctions law. So the more practical concern is that the law authorizes your Chinese counterparty to file a lawsuit in a Chinese court against you to claim a damage which arises from your compliance with a foreign sanctions to refuse to transact with that Chinese counterparty. So then the more practical consideration would be how much that damage could be and how you can mitigate your liability exposure. So far, there has been no published cases showing how a Chinese court will decide on such a lawsuit, but there are some factors which we think you should take into account to inform your decision making in this regard. These factors are, first of all, under this damage claim, could the scope of the damage go beyond what the contract authorizes? I think the answer is generally no. What the anti-foreign sanctions law does is not to create any new cause of action. Rather, what it does is it may nullify certain clauses in your agreement with your Chinese counterparty, which may exempt your liability based on your obligation to comply with foreign sanctions. So if this is a contract dispute, then most of the clauses of your existing agreement with your Chinese counterparty will still be respected by a Chinese court. But it's just those clauses which exempt your liability based on foreign sanctions may be deemed as void by a Chinese court. And secondly, if you have agreed with your Chinese counterparty to submit your case to a foreign forum for dispute resolution, whether it's a foreign court or a foreign arbitral body, would the Chinese court still assert its jurisdiction over that case? If you're a Chinese party, just go to a Chinese court to file a lawsuit against you. The answer is also generally no. However, in order to justify your selection of a foreign forum instead of a Chinese court, there are some requirements under the Chinese law that there must be some foreign elements in a contract dispute. Those foreign elements will need to be reviewed on a case-by-case basis, but if one of the parties to the contract is a non-Chinese entity, then that is a very strong case for making a foreign element in your contract dispute, so that the Chinese court would have to respect your choice of a forum outside of China. So selecting a foreign forum and the foreign governing law in your agreement with your Chinese counterparty is advantageous from the contractual point of view, but there must be some foreign elements to be included in order to justify your selection of a foreign forum or foreign governing law. So let's move on to the next slide. So based on what we have talked about so far, in terms of the general risk mitigation recommendations, what we will usually advise our multinational clients to do in the face of the potential challenges under the Chinese Anti-Foreign Sanctions Law are, first of all, we need to make sure our agreement with the Chinese counterparty have in place those useful contract terms. Those terms could be the force majeure clauses, the termination clauses, or the compliance clauses, which basically emphasize your obligation to comply with all the applicable trade restrictions, including the sanctions, export control measures. And also, those terms should be used in conjunction with a useful choice of law and the choice of forum clause, as we just mentioned earlier, so that when your case is heard by a judge or an arbitrator, your terms that exempt your or limit your liability based on your obligation to comply with the foreign sanctions or export control requirements will be respected. And then, in addition to the protection at the contractual level, you may also want to consider how to proactively communicate with your Chinese counterparty in the face of a potential trade restriction being imposed on your transactions with your Chinese party. So those communications will be helpful to avoid a potential litigation and also to avoid any more serious consequences that may arise from a potential termination or suspension with your Chinese party. We will talk about those more serious consequences in a few moments, but it is useful to have such a communication strategy. And in those communications, you should focus on your empathy and your understanding with respect to your Chinese trade partners' challenge and try to identify a solution together with your Chinese party. And certainly the locus of decision making, if it is placed at the global level as opposed to the local Chinese level, this is also a useful strategy to mitigate the liability of your Chinese legal entity and also your employees with Chinese nationality on the ground. And the last but not least, as we mentioned earlier, using a non-Chinese entity to contract with your Chinese business partner may sometimes be a useful strategy to mitigate the risk of a lawsuit and also make a case that your compliance with the foreign sanctions is just an obligation placed on you as a non-Chinese entity rather than you as a Chinese company complying with a foreign law which is being unjustifiably applied in an extraterritorial manner. So this could also be an argument to mitigate your potential liability. So we are not saying that all these arguments we mentioned would be necessarily acceptable or convincing to the Chinese authority. But if you use all those strategies in a holistic manner, that could be a useful mitigation strategy, as we have seen currently based on the enforcement trend here in China. So let's move on to the next one. Then we are looking at the future development of the Chinese retaliatory sanctions and countermeasures regimes. So we have seen reports from the Chinese legislature basically saying that we now have a quite well-developed, comprehensive countermeasure toolkits. So based on that statement, we see it is unlikely that China will create any new laws in this countermeasure area in the short run. However, it is useful to keep in mind a few things. First of all, the laws are currently still quite vague and broadly crafted. That may be a strategy of the Chinese authority to leave more room for interpretation and exercise discretion depending on the development of the trade tension and the political tension between China and the Western counterparties. So there's quite a lot of room for discretion in enforcing those requirements under the Chinese laws. And also, in addition to the measures provided by the Anti-Foreign Sanctions Law itself, we have also seen some cases in which companies that have violated the blocking provisions of the Anti-Foreign Sanctions Law being punished by the Chinese authority under the measures that go outside the framework of Anti-Foreign Sanctions Law. And those measures could be, for example, some ad hoc trade coercions. A company that has publicly, for example, supported the foreign sanctions under the UFLPA against the Uyghur products alleged with Uyghur forced labor. Those companies, they may see their products imported into China being detained at the border for reason of, for example, disconformity with the Chinese standards. So this kind of enforcement may just go up if there's such a violation discovered by the Chinese authority. And also there could be some public criticism of the company's compliance with say foreign sanctions measures. If they do that in a very high profile, then there could be denunciation by China's state media or social media. And also, as a very recent development, my colleague Tina will be talking about in her section, is that when companies are trying to do the trade partner due diligence under the requirement of the UFLPA and other US sanctions requirements, they may increasingly see the challenge of sharing the result of the due diligence with their overseas party, whether it's a related party within the same cooperation group or a third party, because China has now imposed a new restriction on the cross-border data transfer and the data being controlled for outbound transfer include not just the personal information, but also some important data. And those important data may potentially include the results of such due diligence investigations. So then the challenge for a lot of the companies who are trying to do this type of due diligence investigation would be they need to walk a fine line to, on the one hand, be able to sharing the supply chain due diligence information with their overseas trade partners or affiliates, but on the other hand, they should properly package the information in a way that does not trigger the risk, national security risk assessment required by the Chinese government, and without disclosing too many details, but also satisfy the requirements of the US due diligence regime. So this could be a challenge going forward. We will definitely need to find a solution, and we are still studying the new regulations, but definitely we want to flag this challenge at this point. So let's move on to the next slide. So then we're spending a bit more time talking about the compliance strategies under two specific scenarios. The first scenario is under the UFLPA, there's a compliance requirement of not exporting products to the US that contains products or raw materials that are made with the alleged forced labor. So on that front, we have seen the Chinese government have been adopting a quite pragmatic approach by weighing the interests of the all the relevant stakeholders. But that decision by the Chinese government may vary from case to case. So here we take an example of the solar panel industry, because the polysilicon is one of the materials focused by the US authority as being involving the alleged forced labor. So on the one side, there's a Chinese suppliers who are alleged to have been producing polysilicon with the alleged Uyghur forced labor. But on the other hand, there are a large number of giant Chinese solar panel producers who want to continue their shipments to the US market and complying with the UFLPA. So in balancing these two interest groups, we see that Chinese government has been showing a high level of tolerance toward the second category of companies, those giant solar panel producers, and tolerating their efforts to comply with the UFLPA. And also, we don't think there's a one-size-fit-all solution for all the multinational companies that want to comply with both the UFLPA and the Chinese anti-foreign sanctions regime. Again, just using solar panel industry as an example, we see many companies have been using the strategy of segregating their supply chains for the US destined products from those that are producing products destined for other markets. So for the supply chain related to the US destined products, they may apply more stringent policies to ensure compliance with the UFLPA, but for the other supply chains, they may adopt a different compliance strategy. And this approach, the benefit of this approach is it ensures compliance with the UFLPA, but on the other hand, it also minimizes the impact on the upstream suppliers of the raw materials. This approach has been largely adopted by many Chinese solar panel companies, and it has so far been working quite well, at least from the Chinese government's perspective. And from the multinational companies' perspective, if you are cooperating with a Chinese trade partner that has been proactively sanitizing their supply chain, the risk of triggering the anti-foreign sanctions regime would be relatively lower as compared to the strategy in which you impose on your Chinese partner to terminate or suspend their businesses with their upstream suppliers. And that strategy could be regarded by the Chinese government as violating the anti-foreign sanctions law, because your requirement from the Chinese law perspective is without the legal or business justification. So this is maybe something we can consider in deciding a appropriate strategy to ensure compliance on the requirements on both the US and China side. And last but not least, you should also consider the optics from the general public in China. That will require that you have a good communication strategy, as we just mentioned earlier, to properly package your compliance program under a broader theme of, for example, ESG or responsible sourcing, as opposed to forced labor compliance, which could be quite irritating from the Chinese general public or government's perspective. And then move on to the next slide, please. So the next scenario we just want to very quickly touch upon is the compliance with the Russian sanctions regime from the Chinese perspective. So similarly, we have seen the Chinese government has been adopting a quite pragmatic approach by balancing the interest of the various stakeholders. One example in this respect is the Chinese state-owned financial institutions. They have a more vested interest in complying with the US sanctions against Russia, as well as other countries. So those companies may be more tolerated by the Chinese government for their compliance with the Russian sanctions as compared to the other ordinary companies operating in China. And also an important factor to keep in mind is that when your compliance efforts do not result in any suspension or termination of business with a third-party Chinese trade partner, then the compliance risk with respect to the AFSL could be quite low. But on the other hand, if you're trying to, your compliance with the Russian sanctions have result in harms to your Chinese trade partners' interest, then that could be some implications from the Chinese Anti-Foreign Sanctions Law. And in dealing with this kind of a situation, there are a number of factors we should take into account. First of all, when you suspend or terminate your business with a Chinese trade partner to comply with the Russian sanctions, you need to evaluate whether this kind of move is necessary under the US sanctions against Russia, because any overcompliance with the Russia sanctions regime could be considered very unfavorably from the Chinese government's perspective. And then secondly, you should consider, as we mentioned earlier, what is the potential damage claim that you can be subject to if you move on to terminate or suspend your business with your Chinese trade partner. What would be the likelihood of the potential litigation, and what would be the potential scope of damage? And that should be weighed against the potential implication under the US law for violating the US sanctions. And also there are social and the political impact to the potential termination with your Chinese counterparty, because in addition to the damage claim under the contract, there could be also other consequences arising from that act, as we just mentioned earlier. So overall, you should have a good evaluation about your contractual setup and the supply chain arrangement to see if there's any room for further improvement to mitigate the risk. You may also consider a review of your contract terms to add the useful clauses, as we just mentioned earlier, or you can consider restructuring your supply chain if there's any possibility to further mitigate the challenges in this regard. So with that said, I will hand this over to my colleague Ivy to talk about the new development under the Chinese export control law.
Thank you, Frank, and hi, everyone. Thanks for joining us today. So let's shift gear now and talk about some of the developments from a China export control regime perspective. So as most of you would be aware by now, China has finally passed its export control law in 2020, and the law has since become effective. So the export control law, excuse me. So the export control law provides for the key principle that forms the backbone. Excuse me, apologize for that because I've only just recovered from COVID. So I don't have the best voice today, but so just bear with me. So as I was saying, The export control law actually provides for the key principle that forms the backbone of China's export control regime, and the detailed information on how the rules would actually be implemented and applied would actually be expected in the relevant implementing regulation. So after a long wait, the MOFCOM China has finally released the first draft of the regulations on export control for public comment in April of this year. So while this draft regulation has not been finalized, we thought that it would be useful to just summarize some of the key takeaways with respect to this draft. So first of all, we observe that the draft regulation contains references to the establishment of export control classification codes, as well as country of destination risk rating system. So that seems to suggest to us that China may be looking at adopting classification systems such as the alphanumerical ECCN that we see implemented in other jurisdictions, as well as the country chart. Currently, dual-use items that are subject to export control in China are primarily identified based on technical description, as well as accompanying tariff classification codes for certain physical items where those codes are provided. So that is somewhat different from what we see more commonly applied as an international approach. So if MOFCOM does proceed to apply or implement an ECCN country chart regime, that would generally bring the China export control regime more in line with the international approach. What we thought would also be interesting is that the draft regulations actually specifically prohibit Chinese individuals or companies from cooperating or committing to cooperate with agents of foreign governments in any on-site export control interviews or investigations conducted in China. And this could be investigations or checks with respect to end-use and end-user requirements, unless a MOFCOM approval is obtained. Now, the draft regulation does not provide for further information on how MOFCOM's approval may be obtained with respect to this requirement, what are the factors that they would consider in order to provide this approval. So it is still unclear to us at this point how this restriction would likely impact Chinese companies' ability to comply with the export control laws under foreign export control regimes. Next, can move on to the next slide. Yeah. So the draft regulation also further elaborate on the licensing options under the export control law. Generally, there are two types of licenses available. Firstly, the general license regime, which provides for or allows the export of multiple types of approved items to multiple end users over a period of time, as well as a specific license regime, which generally is a one-off approval for the export of specific items to specific end user. The rules also provide for some of the factors that will be considered in order to determine when a general export license will be available. And these factors includes the exporter's export compliance status, implementation of an ICP, internal compliance program, the exporter's export records, historical license application record for the past 2 years, the stability of the exporter's transaction flows and sales channels, and etc. So we compared these to the old export license regime and note that there are not very, very significant differences. So hopefully that stays to the case. Now, can we move on to the next slide? The export control law is also generally silent on the availability of exemptions on licenses in certain circumstances. So what the draft regulation does is that it introduces certain license exceptions that may be available in certain instances, and that includes where an exporter re-export goods that have been brought into China for maintenance, testing, or inspection purposes. The re-export of goods brought into China for the purposes of exhibitions to be held in China. The export of civil aircraft parts and components for maintenance purposes and other circumstances prescribed by MOFCOM. So that we expect would likely facilitate some of the business activities for companies operating in China. Now, with respect to end-use control, the draft regulation also clarified that when there is a change in the end use of an exported item, obligation is actually placed on the foreign end user of the exported item to apply to MOFCOM for an approval of the anticipated end use change. But such application should be submitted through the Chinese exporter. So the Chinese exporter would have an ongoing obligation with respect to the end use control of exported control items. The draft regulation also provides that with respect to the export of goods that fall within the scope of the catch-all provision, i.e. the export of items that are not listed on any of the controlled lists, the exporter as well as the foreign importer are also obliged to report to MOFCOM any risk to national security and interests, as well as risk of involvement of the items in any weapon of mass destruction or terrorism related activities within 3 years after the date of exportation. So 3 years is a rather long period, so that should be something that should be taken into account in the ICP that businesses built or put together for the purposes of complying with the Chinese export control law. Next, we also have more information with respect to the blacklisting mechanism that is put in place under the export control law. This is generally the equivalent of the entity list in the US. To recap, parties who may be blacklisted under this blacklisting regime would generally include people who have breached the end use or end user requirements with respect to control items exported from China, or any party who may pose a potential danger to China's national security and interests, or may potentially use any control item that has been exported for any terrorist related purposes. So once a person is listed on the blacklist, the authorities would then have the power to take certain steps, such as prohibiting any or part of its exports, refuse to grant any license where a license has been applied for. Even where a license has been issued, the authorities would have the power to revoke the license. The authority may also order the suspension of any related export that has not been completed, or take any other necessary measure. And as you can imagine, general licenses and license exceptions, any licensing facilitation measure that's available under the export control law would also not be available to any parties who are listed on the blacklist. The draft regulation also emphasizes on the responsibility of third parties who are involved in the supply chain that involves exportation of prohibited goods or controlled goods to an overseas party. In particular, any person or company that is engaged in the provision of agency services, freight, delivery, customs declaration, e-commerce trading platform, financial services, etc., are required to cease such activities once they're detected and report the same to MOFCOM upon discovery of any prohibited or export control violations. So even though these parties are not exactly the exporter of record for the goods exported out of China, they're also encouraged to implement compliance programs of their own. Lastly, the draft regulation, once formally adopted, would also put in place a mechanism for MOFCOM to work with other governmental agencies, who are in charge of, amongst others, public security and national security, financial regulation, customs, public transportation in enforcement activities. So with this multi-agency collaboration, can be expected that enforcement activities with respect to the export control law may be intensified over time. So that's a quick summary of the draft regulation. Let's move on to the next slide to look at some of the recent developments relating to technology import and export regulation. So currently, in addition to the goods, software, technology that are caught under the dual use catalog, China also has in place a separate technology import and export regulation, which provides for restriction or prohibition on any cross-border transfer of technology that are captured under the relevant catalogs. This regime has actually been around for some time, but it has not attracted significant compliance effort up until recent times. So following a flurry of changes made to the control catalogs in 2020, MOFCOM again made some revision to the catalog of technologies that are subject to import prohibition and restriction, basically to restrict the importation of data encryption technology, which employs a key length greater than 256 bits. So what that means is that for the importation of data encryption technology that falls within that scope, as described, an import permit will be required for the importation. The key challenge with respect to the technology regulation is that not only is it separate from the dual use regime, there is also a broad definition for technology transfer, which includes, amongst others, assignment of patent-related rights, assignment of technical secrets, technical services, transfer of technology by any other means, which makes it challenging for businesses to define the exact scope of control. In particular, businesses sometimes find it challenging to determine when an import of encryption software or software containing encryption capability would fall within the scope of the control. As such, companies that are importing encryption-related intangibles should generally be aware of this development, and for that sort of import transaction, we should always look at the technology regulation to see whether or not the intangible transfer is caught, and if so, an import license may be required. Note that the technology regulation fall outside the scope of the dual use and encryption regime, which currently only impose import control with respect to 4 types of physical encryption devices. So this applies separate from those regimes that I just mentioned. Now, for the purposes of the Chinese export control law, MOFCOM has issued a set of guidelines pertaining to the establishment of an internal compliance program, an ICP, and it generally sets out the key elements of a good ICP. That is generally summarized on the slide. With respect to the ICP, a comprehensive risk assessment is a crucial element to the ICP, and it would generally comprise of product screening to identify control items, as well as end-use and end-user screening, which include the screening of customers against Chinese sanctions list, which Frank described earlier in detail, the blacklist under the export control law, which has yet been issued, and more importantly, to identify potential risky end users that could potentially be regarded as threatening to China's national security, or be at risk of being used for WMD or terrorist purposes. In particular, national security is not defined, so that could potentially be interpreted very broadly. With respect to product screening, some of the key challenges that we observe relates to the reconciliation of requirements under a number of the different regimes, the export control law, the dual use regime, and the technology regime. This is especially the case because the classification of the goods may be different from international standards, as well as from one regime to another. So for this specific reason, note that specific screening processes or steps should generally be implemented based on the specific type of products or technology that a company deals with. So for example, for a tech company, you may wish to focus on the classification of encryption products and tech-related technology under the technology regime. So specific questions should be crafted and asked in specific manner so that the product screening process can be operationalized, and companies should also ensure that product screening process is carried out every time a new product is introduced. With respect to the end use and end user control, again, this is a challenging area because of how broadly national security concerns can be interpreted. That said, we generally observe that companies should generally do a detailed review of the supply chain structure, including to look at the type of goods or technologies that it supplies, the type of customers that they deal with, to determine when additional screening measures should be conducted for end use due diligence purposes. So take, for example, where end users are military or government agencies, or foreign countries, or where the goods exported or technology exported is likely to have military end use, the more stringent due diligence processes may be required to show that the company has taken adequate steps to ensure end use check. And these enhanced checks should also usually be tailored based on the specific type of risk identified for the specific company. Regular rescreening of existing customers or end users should also be considered to ensure that new potential risks arising from the export can also be identified during the 3-year duration as required by the draft regulation, in case the draft regulation actually gets passed as proposed. Some of the other compliance challenges that we often see relates to the application of deemed export. Currently, there's considerable ambiguities with respect to this application of deemed export control, as there is no specific mechanism for application of export permit for deemed exports, and existing guidance on the application of the rule is rather limited. So what businesses should also do is to ensure that you're kept abreast of the related developments to ensure that we continue to ensure compliance with the relevant requirements. So that brings me to the end of my segment, and I'll pass the time over to Tina to talk about cybersecurity law and technology restrictions. Over to you,
Sure.
Tina.
Yeah, thanks, Ivy. So in this very next section, we will walk through several supply chain considerations under the cybersecurity law and a certain market access restrictions relating to the foreign technology. So to start with, we would like to start with this a very recent legal update. The Cybersecurity Administration of China has just finalized and published this measures for security assessment of transfer of data abroad a few days ago. The new measures will take effect from September the 1st of 2020. So this marks that the requirement of security assessment on the export of data will start to be implemented in 1.5 months from now. In respect of the type or scope of the data that will trigger this requirement, it includes first, if you're providing important data abroad, and second, if you're providing personal data that meets certain criteria, for example, the volume threshold, etc. So it worth noting that for important data, there is no quantitative threshold requirement. The legal definition of important data is very broad. So in practice, companies in China, they are now referring to a draft national standard, which they would refer to as a guidance to identify the scope of the important data. So according to this draft guideline, information that can be considered as important data include the technical data subject to the China export controls. And also if you're transferring information related to the China military or national defense abroad, this can also be considered as transfer of important data. And the third type that we would like to notice if the information that China can be considered as crucial to the national security. For example, just as Frank has mentioned earlier, and this could include information that you gathered in China when you were conducting export control due diligence against the Chinese end users. This could also be captured by the scope of important data, so as you need to obtain the security assessment clearance from the Cybersecurity Administration of China. So due to the very broad and vague definition of the term important data, so one direction that we can consider to work towards is to develop a framework to refine the scope of the data that we are sharing from China to our foreign counterpart, and consider to take the mitigating strategies to mitigate the potential compliance risks. Next slide, please. Yeah, so on this slide, we will quickly go through the several supply chain considerations under the cybersecurity regulations. So the first one is the product certification and inspection requirement. So China keeps a catalog or a product list to identify certain products critical to the cybersecurity. Any required product on the list must pass the certification or inspection in order to be distributed to the Chinese users. So another similar regime to this is and also this can sometimes overlap with the certification or inspection requirement is the MOPS license. So if you're selling information security products in China, you should obtain a sales license issued by the Ministry of Public Security, or what we call as the MOPS license. Next slide, please. So on this next slide, we talk about the regulations relating to encryptions. So there has, as my colleague Ivy has just covered, there has been several developments in the past year. So to sum up, if your supply chain involves encryption, you should be mindful of the following control regimes. The first one is the dual use control regime under the Export Control Law of China. So under this regime, China also adopts a list-based approach to determine the scope of encryption items or technology that is subject to the import and export controls. So currently on the import side, the control list only contain a very limited number of tangible encryption devices. But this doesn't mean that the import of encryption technology is free of control. As Ivy just introduced, China also has in place this legacy technology import and export regime. And in particular, as a result of a recent amendment in November 2021, data encryption technology with a security strength greater than 256 bits is now added into the import control list. So in respect of how this restriction would be implemented, there are several points to be considered. The first one is what exactly is the meaning of security strength over 256 bits. If it simply refers to the key length, we understand it's not a very hard standard to meet. And if that is the case, the majority of the encryption technology would be caught. So for this question, MOFCOM internally issued an unofficial guidance to translate the security strengths of different types of algorithm, for example, the symmetric algorithm, into the security strengths. So MOFCOM would refer to this internal guidance to identify the technology that will be subject to this control. And the second pending question is whether the transfer of encryption software will be controlled. So due to the definition of the technology subject to control, because this definition is very broad, so we may need to consider several factors when we analyze whether the proposed transfer will be subject to control. So these factors are the factors that we should take into consideration include, for example, what is the way of delivery, whether you're delivering the source code or the object code, and also whether the software is licensed together with the hardware, or whether it's a separate license. In addition, the payment terms is also one of the factors that we should consider when we perform the analysis. So given the uncertainty and ambiguity content by this current control regime for trade compliance purposes, to tackle this issue, we should develop a legally valid analytic framework and consider the mitigating strategies to mitigate the potential compliance risks. So in addition to the several import and export related restrictions on encryptions, on the domestic side, currently there is no longer in place such general prohibition on the use of foreign developed encryption items. And also encryption items are no longer subject to the mandatory product certification or inspection requirement, but rather China would encourage such products to be voluntarily certified or inspected to increase the competitiveness on the market. However, even though we call this a voluntary certification regime, this can sometimes be a de facto mandatory under certain circumstances. For example, if you're selling encryption related items, if you're bidding for a government procurement project, it can be the case that the government purchaser would require your products need to be certified. And another example is, for example, when you're applying for the MOPS license, and also if your product is at the same time a encryption item, obtaining the encryption certificate can be a precondition for the authority to issue the MOPS license. The other market, on this slide, we will cover some other market access considerations for foreign technology or high-tech products. The standardization law of China contains a provision that encourages industry associations or companies to formulate the product standard based on the independently developed innovative technologies, which is a term used to refer to the localized technologies. So following this requirement, there has been news articles reporting that China is also planning publishing some regulations that will contain this localization requirement, meaning that it will require the technologies contained in certain IT products used in strategically important industries would require the technologies contained therein must be localized. So the draft regulation hasn't been published yet, but so far this requirement, how it will be implemented remains unclear. But once the regulations are rolled out, there are several critical issues worth noting. The first one is what exactly is the technology localization means? Does it mean that the technology content in the product must be originally developed in China? Or it simply requires that as long as the technology comply with a Chinese standard, it will pass this requirement? Or it will require the technology to be transferred to the Chinese counterparty so that the product can be marketable. So these are the questions pending clarification when the regulations finally come out. And the other questions to be clarified include, for example, what exactly is the scope of the strategically important industry, and what is the scope of the IT product that might be subject to this requirement. And also it was following up how this localization requirement will be enforced. So with that, let's move on to the next slide. So in the very last topic of today, the very last topic of today would be the pilot project recently launched by China in Shenzhen City, which provide a more aligned approach in managing the transfer price and customs valuation. So before we move on to this new policy, to give a very brief background about why making retrospective transfer pricing adjustment is so hard in China. So under the current regime, retrospective TP adjustment in China is very difficult to implement. This is because there is no formal measures to follow, and also because China exercise very strict foreign exchange controls. So even if you're making an adjustment on the book, there is not a very effective way for the Chinese companies to repatriate the cash out of China for the adjusted price. So as the result, in practice, companies in China, they would often just try to avoid making such retrospective TP adjustment, or it can only do so following a formal customs investigation. So where the result of the investigation is that China Customs required a company to uplift their import price and pay the underpaid duties. In that way, the price might be adjusted. So on the next slide, we talk about the more details about this new policy. So 2 months ago, the Customs and Tax Authority of Shenzhen, which is a southern Chinese city, so published this new policy. And this new policy marks the first mechanism in China to officially allow companies in China making retrospective TP adjustment. In order to join this program, the applicant company needs to proactively engage both the customs and the tax authorities, and among the three parties negotiate for an aligned approach to make the adjustment. So the topic that the parties need to reach alignment, including what benchmark to use, what is the timing to make the adjustment, and what is the target to choose, etc. So it bears noting that one condition required for a company to join this program is that the company should have in place an advanced pricing agreement, or called the APA, with the tax authority. So this can be either a unilateral APA or a bilateral APA. So once both authorities has been aligned on the topics that we just covered, the company would be permitted to make the retrospective adjustment in the timeline that just agreed among the parties. So they are allowed to make adjustment to the import price in order to meet the target, the financial target as aligned with authorities. So this adjustment can either be an upward or a downward adjustment depending on the actual financial result. On the next slide, we share some comments and suggestions relating to this new policy. So this new policy indicating that China is taking one step further into a more aligned management approach between China Customs and the Tax Authority on customs valuation enforcement. So and also the policy indicate that if a company's transfer pricing method and their profit target has been formalized and memorized by an APA and endorsed by a Chinese tax authority, it is more likely that such TP method will be easier to be accepted by the Chinese customs authorities as a basis for customs valuation. Another takeaway is that even though at the moment this policy is only officially available to companies in Shenzhen, it still shows a tendency of China that the tax and the customs authority will get a closer alignment on the customs valuation issues. But on the other edge, it also worth noting that companies should be mindful of the potential customs valuation issues when they're preparing their transfer pricing documentations. So in this process, inputs from the customs valuation expert can also be important. Along the same line, as the tax and the customs authority are more aligned, so experts on those topics should also take a more aligned approach when they're tackling the new challenges. So with that, I will pass the control back to John to wrap up the session.
A couple of questions that individuals have asked. One person is asking, with respect to encryption controls, and especially the import or export of encryption products and technologies, are there any so-called license exceptions similar to the license exceptions that we have in the United States for export of encryption products? Or would, if they fall within the jurisdiction of the export controls or the technology import-export rules, in all instances will you need an export or import license or permit? So I don't know if that's for you, Ivy, or for you, Tina, or both of you.
Thanks,
Yeah,
Sean. I can take. Our friend can take the question.
No, sorry. Yeah. Yeah. In the interest of time, probably I can take that one. So the short answer is there's no exception under the Chinese law equivalent to ENC under the EAR. However, the control list of the encryption items under the Chinese law should have already excluded those so-called mass market products by virtue of the requirement of the encryption law of PRC. So although there's not formally an ENC exception under the export control law itself, if your products happen to fall under the scope of the control list of the Chinese law, but you believe your product belongs to a mass market product, there could still be a valid argument to make in front of the Chinese export control and encryption authorities trying to exclude your product from the scope, just by application of the general principle under the encryption law that mass market product should not have been included in the scope of the control list.
Thank you, Frank. As kind of a corollary to that, Tina and Ivy, when you were speaking about the encryption rules, both with respect to the export control law and with respect to the technology import and export regulations, you mentioned those both under the authority of MOFCOM. It's my recollection that historically the licensing or permitting authority was a separate agency, the State Encryption Management Board, or and has that organization been folded into MOFCOM now? Is MOFCOM the licensing authority, or does SEMB still have some authority over the import and export of encryption items?
Sure, thank you, John. So under the current regime, even though both regimes are supervised by the MOFCOM, but they are overseen by different sub-department under the MOFCOM. So for the dual-use control regime, it is supervised by the Import and Export Security Bureau under the MOFCOM, and on the other side, the Import and Technology is supervised by another department. And with respect to your question, whether the SEMB still have a authority in the licensing regime. So under the under the old regime, before the regulation of encryption has been merged into this dual-use control list, SEMB used to be the issuing authority, but now MOFCOM would be the authority to issue the license. But in the process, when they issue the license, they may still internally, the MOFCOM may still internally consult the SEMB for technical consulting from a technical perspective.
Thank you, Tina. Thank you very much. Well, we are at the hour, and I want to be respectful of the time. So I think I should probably bring the session to a close. I really do want to thank Frank, Ivy, and Tina for joining us this afternoon and sharing this really terrific information. not readily available from other sources and very timely indeed, especially with respect to the data security and some of these very recent export control developments. So thank you all very, very much. A big thanks as always to our great support team, Jen, Liz, and Nazi for their help in all the logistics of the program. I do hope that these 3 sessions today have been helpful to all of you. And I certainly hope that you can join us tomorrow when we shift our focus and focus again on issues with respect to Russia, both in terms of the growing area of sanctions by a number of countries directed at Russia and the Russian counter sanctions or countermeasures in response to that. So I do hope you'll be with us for the 3 sessions that we have tomorrow in the program. In the meantime, as we adjourn and when you go off the webinar, there is an evaluation sheet, and we very much welcome any comments, any suggestions, any points that you may want to share with us. It's the only way we get them with that feedback, the only way we can really get the information we need to continually improve the quality of these programs. Well, with that, thank you again, everybody, and hope to see you again when we start tomorrow morning.